Welcome, class. Settle down. Today, we are diving straight into a highly technical, absolutely crucial area of property law. I'm going to give you the exact word-for-word blueprint you need to completely master Question 18 on Section 69 of the Transfer of Property Act 1882. If you want to secure maximum marks on your KSLU answer script, I expect your absolute undivided concentration. When this question appears on your paper, your approach cannot be casual. It must be methodical, highly structural, and perfectly precise. All right, let's begin.
Now for our structural agenda, we'll be moving through this systematically. 1. General rule and exceptions. 2. When is sale allowed? 3. Mandatory conditions for sale. 4. Effects and purchaser protection. 5. Practical illustrations. And 6. Landmark case laws. Memorize this exact flow, students.
Moving right to heading number 1, general rule and exceptions.
Here is the absolute baseline you must know. Ordinarily, a mortgagee must approach the court. A mortgagee cannot sell mortgage property without a court order, except in cases expressly provided under Section 69. Now listen carefully to me. Before you write a single explanatory paragraph in that answer booklet, you must establish this foundational boundary. You cannot, I repeat, cannot discuss the exceptions without first cementing the rule. Write this out exactly and underline this fundamental principle in your exam. You have to show the evaluator that court intervention is the absolute default position. Why? Because the law doesn't favor private sales of mortgage property. It risks exploiting the poor mortgager. Section 69 is an exception to this cardinal rule, and so it must be interpreted strictly.
Let's move to heading number 2. When is sale allowed under Section 69?
What are the strict statutory exceptions? First, an English mortgage where the mortgagee is the government or a public authority. Second, a mortgage deed that expressly confers power of sale specifically in notified areas. And third, certain notified towns, namely Mumbai, Chennai, and Kolkata. Students, you will dictate these 3 distinct bullets verbatim in your answer script. And here is a pro tip for you. Write these points as unmerged, clearly numbered items with a black pen. That is going to immediately capture the examiner's attention. If you just lump these together in a messy paragraph, you are throwing away marks. Notice the precision required. It's not just any mortgage. Point 1 mandates an English mortgage with a government or a public authority. Point 2 requires an express clause in the deed itself. And point 3 explicitly names the major commercial hubs: Mumbai, Chennai, Kolkata. Precision here is simply non-negotiable.
Okay, heading number 3, mandatory conditions for sale.
Now, even if your mortgagee falls into one of those 3 exceptions we just covered, they can't just wake up one morning and auction the property. No way. There are rigid procedural hurdles they must clear. Step 1, a written notice to the mortgagor demanding payment. Step 2, the default continues for 3 months or interest is unpaid for 500 rupees or more. Step 3, the sale must be bona fide, meaning in good faith. I am dictating these steps to you in strict chronological order because sequencing is absolutely vital here. First comes the written notice. An oral demand on the phone, legally void. Second is the waiting period. That default must persist for a clear 3 months after the notice, or there has to be unpaid interest of exactly 500 rupees or more. Third, the overriding equitable principle. It must be bona fide. The sale cannot be a fraudulent mechanism just to strip the borrower of their equity.
Right on to heading number 4, effects and purchaser protection.
So what is the effect of the sale? The purchaser gets a good title and the sale cannot be easily challenged. And for protection, under Section 69A, the purchaser is not affected by irregularities in the sale. The remedy lies against the mortgagee. In your exam, you absolutely must explicitly cite Section 69A under this heading. It shows the evaluator you have comprehensive knowledge of statutory purchaser protections. Look, if a purchaser buys property in a Section 69 sale, the law shields them. Even if the mortgagor made a procedural blunder, say the notice was flawed, that innocent purchaser still gets good title. The aggrieved mortgagor's only remedy is to sue the mortgagee for damages, not to evict the purchaser. This is exactly what ensures market stability for auction properties.
Heading number 5, practical illustrations.
Let's look at a clear comparison. Scenario 1. A mortgages property to a bank with a power of sale clause. A defaults after notice. The bank can sell without the court. Scenario 2. If no such clause exists, the mortgagee must go to court. Now, I strongly advise the classroom to draw a clear T format in your answer script or use 2 distinct paragraphs to visually highlight this contrast for the evaluator.
In the first scenario, that express clause acts like a trigger for the Section 69 exception. In the second scenario, without the clause, the mortgagee is trapped in the general rule and forced into the judicial system. It's a brilliantly simple demonstration of the law in action, and frankly, examiners actively look for these practical illustrations to separate the average student from the true top scorer.
And finally, heading number 6, landmark case laws.
Pay very, very close attention here. This is the absolute most critical section for securing those top marks. Without judicial backing, your answer is fundamentally incomplete. First case, Narandis Karsdondis versus S.A. Comptum. I strictly command you to draw a distinct box around this case name in your exam. Let's break down the facts. The mortgager defaulted, and the mortgagee initiated a private sale under Section 69. The mortgager tried to stall the whole process, claiming their equity of redemption wasn't extinguished just because an auction took place. Well, the Supreme Court's ratio decidendi here is brilliant. The court held that the mortgager's right to redeem is only lost when the sale is absolutely complete and the registered deed is finally executed in favor of the purchaser, not merely when the auction hammer falls. This is highly relevant because it perfectly balances the mortgager's statutory right to sell against the mortgager's ultimate right of redemption under Section 60. Now, the second case, LK Trust versus EDC Ltd. Underline this case name immediately to grab the KSLU evaluator's attention, especially for a 16-mark answer. The background involves a statutory financial corporation exercising its power of extrajudicial sale. The ratio decidendi clarified the absolute validity of a sale without court intervention, provided the strict statutory powers are conferred and conditions are met. Why does this matter? Because it completely validates the extrajudicial mechanism under Section 69 as long as the mortgager strictly adheres to the procedural mandates. Don't invent facts in your exam. Just state these core legal principles derived exactly from the established precedent.
Let's wrap this up. I want you to write down this final authoritative closing statement word for word. Quote, "The power of sale without court is an exception to the general rule, allowed only in specific circumstances. It ensures speedy recovery of debt while safeguarding borrowers' rights through strict conditions." Unquote. Use this exact paragraph as your conclusion. It perfectly synthesizes the legislative intent. It balances the mortgage's need for a speedy recovery with the borrower's need for strict procedural safeguards. If you follow this rigid, highly structured blueprint, you literally leave the examiner no choice but to award top marks. So, are you now fully equipped to conquer this crucial property law question? Review your notes, internalize this structure, and apply it flawlessly. Class dismissed.